Except I'm late. Good morning. It is 10:01, but we're going to begin our meeting as soon as we have quorum. Oh, there you are. I'm so sorry I didn't see you.
I thought you did. You were being funny.
No. My children thought that I had eyes in the back of my head, but apparently they were wrong. So good morning, and with apologies for the late start, I'm calling to order this meeting of the Public Safety and Justice Committee on Tuesday, January 16th at 10:01 a.m.
All right.
You begin with a roll call, please.
Vice Chairperson Chavez.
Here.
And Chairperson Ellenberg.
I am here as well.
You.
All right, we're going to move to public comment, which is the portion of the agenda set aside for members of the public wishing to address the committee on matters not on today's agenda, but within the purview of the Public Safety and Justice Committee. Do we have speakers, Colin?
We have one request to speak online.
All right, let's offer that speaker 3 minutes, please.
All right, the next speaker, you have 3 minutes to speak, and the timer will start when you begin speaking. If I could have the resident unmute your microphone. There we go, thank you.
Yes, good morning. I've been addressing this committee for a few months now because my kids are being sexually abused and there's nobody willing to help me. And it's really a travesty because, I mean, we hear about the negligence of the county in terms of a baby dying. And I mean, it's just a no-brainer that when a child complains about being anally raped at age 13, and other children are showing signs of the same sort of abuse, that you'd have an assessment done. I mean, we don't need to be a social worker. We don't need to be a rocket scientist. I mean, you have an assessment. And when I started complaining about what was happening to my kids, instead of anything being done, charges were filed against me by the district attorney's office for not even a crime being committed. And the problem is that there's a conflict of interest because a private attorney, Valerie Houghton, is financially gaining from the sexual abuse of my kids. And she says, pedophilia is not a crime. And she also says that pedophilia is part of gender identity. And furthermore, she says that it's not rape if they want it. I mean, these are her words. I forwarded the statements to the district attorney's office, and nothing's being done. It's just terrible what's going on in this county. And I get it that you guys are the best. You guys are in power. And it's only your kids that matter. And my kids are just shit. That's what they are. They're shit to you guys. And you guys won't do a damn thing because Valerie Houghton and Judge Towery, that's the way they want it. They want my kids to be raped. And you guys, only your kids matter and only your kids deserve protection. And every time I speak to you guys, all you guys do is act like I never said a thing. And you guys go about your business like my kids aren't being raped, and it's just, I can't believe you guys. I mean, you guys should be saying, oh, your kids are being raped, what can I do? What can I do? The sheriff should be saying that. The DA should be saying that. Children and Family Services should be saying that. But you guys just ignore me. Like, my kids aren't your prostitutes to pimp out with Valerie Houghton. I mean, I posted this all online. If you guys want to see it again, all you have to do is Google Valerie Houghton sex trafficking, and all the details are there on multiple sites. Thank you very much, and I hope you guys do something. Please do something. Thank you.
And that concludes our request to speak.
Thank you very much. Approval of the consent calendar and any changes to the committee's agenda is in front of us next. Supervisor Chavez, do you have any changes to the consent calendar?
I would move approval.
Thank you. I'll second that. Do we have public speakers on? Oh, sorry. Yes. Do you have changes to the? Okay. Do we have public speakers on consent?
There are no requests to speak in the room, and there are no requests to speak online.
All right. Let's vote on this item, please.
Vice Chairperson Chavez.
Yes.
And Chairperson Ellenberg.
Yes.
Motion carries. Thank you.
Thank you very much. Item 4 is to receive a report from the Office of County Counsel and Administration relating to bail reform efforts and the implementation status of the bail and release work group recommendations.
Good morning. So we have on the agenda today an update on the status of recommendations coming out of the bail and release work group. I realized in putting this together that we are at exactly a decade from when the board formed the bail and release work group under the leadership of Supervisor Chavez, and it's to this day one of my favorite projects that I've ever had the good fortune to work on. I see Greta nodding as well. It's one that I always cite when speaking to law students and other new lawyers who are thinking about joining our office. So what we've put together is a brief chart that walks through all of the 18 recommendations that group came up with, and many of the people who are sitting up here today were members of that group and worked together to develop a series of consensus-based recommendations. We're happy to either walk through the items one by one and briefly discuss the status, or focus on any particular items that you'd like us to focus on, or just answer questions. The primary speakers on this item will be myself, Matt Fisk, and Casey Halcone, with support from some of our other colleagues.
Supervisor Chavez, do you have a preference?
You know, I would actually really love to hear what the highlights that you all are looking at and where you see our kind of what the overall next steps are. And thanks for reminding me how long ago that was. But that's powerful that it's been moving for this long.
Sure. So I'll just say by way of introduction, a couple of comments, and then I will look to Matt and Casey. We've kind of divided up the items into the ones within each of our subject matter areas. Just by way of introduction, when we were sitting down, a dozen or more of us a decade ago to work on these items and perform research into best practices on bail and pretrial reform, to look at what jurisdictions around the country were doing that we maybe should adopt as a model or adapt for our local purposes. It was at a time when pretrial justice reform wasn't really a huge part of conversation statewide. It was before a state ballot initiative and state legislation on this issue. We were really acting locally according to, the best available information that we could have at the time, and the wisdom of all of our partners who are up here and in our departments as well. And we were trying to think of both sort of more immediate implementation type ideas, as well as larger, more ambitious policy reform ideas, so that what we came up with could really, run the gamut from we can do this today versus this will take several years to really get it up and running, in a clean way. And so what you see reflected here in the 18 recommendations, I think, shows that. Some of them are, hey, why don't we do things like under number 1, take our existing efforts, like the jail diversion and behavioral health subcommittee of the reentry network that was in effect at that time, and make sure that pretrial considerations are an express part of its work. Let's bake them in the same way that in the last year, the board has been having discussions about baking equity into budget decisions and other things. So some of them fall into that type of category, and then some of them are really much more specific policy reform recommendations. So why don't I see if we could start with, maybe I'll start with number 2 and then turn it over to Casey to walk on from there. We won't do every single one. Maybe we can just each speak to the sort of the highlights.
Perfect. Thank you.
Great. Okay, so number 2, the recommendation, and maybe I should put up the chart actually so we can all see it together. I can get my Zoom to open. Okay. So I'll start with item number 2, which is explore feasibility of establishing a public or nonprofit alternative to commercial bail bonds. The background on this recommendation, the idea was to try and create a non-profit-driven alternative to commercial bail bonds that would allow people who don't have the means to post their own bail to find a method to do so without having to rely on bail agents who charge non-refundable fees and have other practices that, as the work group uncovered, can be exploitative. So it's difficult from a legal standpoint to have an alternative to a bail bond agency that's run within the county by the county for reasons that are technical and I won't go into. But the front runner became the idea of a community bail fund. And that exists in other jurisdictions around the country. And the gist of it is you have a nonprofit community agency that typically for really low dollar value bail, $1,000 or less, $5,000 or less, that kind of thing, through philanthropy and other means, raises money, pays people's bail. When they make all of their appearances, that bail is refunded at the end of the process, and it can go back into the fund to be used for others who lack means and who have these low seriousness offenses and low bails. And typically, the other benefit, unlike commercial bail bonds, is that there's services provided to people as well. With a bail bond, you get the money, you get no support in making your court dates, in preventing rearrest, that sort of thing. So at the board's direction in 2018, County Council and administration worked together to issue an RFP, and unfortunately got no takers on that idea. I think the idea, or the reason for that is, we obtained input on the kinds of things that would be beneficial in a program like that, but we understood that a lot of organizations at that time felt that they lacked the capacity to take on especially the financial management side of things. So we haven't revisited the idea since then, but that is where it last stood.
Good morning, everybody. I'm going to make brief comments on number 3, and then I'm going to skip to number 10, unless anybody has questions on some of the intervening items. But for number 3, so there's definitely opportunities and continues to be opportunities for state legislative advocacy for pretrial justice. So in the intervening decade, as Kavitha mentioned, there has been quite a few legislative changes that have really expanded our work in pretrial justice reform, but that's not to say that we're done. And so my understanding is, and I know Chairperson Ellenberg, that you'll be talking a little bit about the work plan for the coming year, but Deputy County Executive David Campos and the intergovernmental team will be coming to talk a little bit about what are some opportunities this legislative cycle and priorities for our county should we want to either support active legislative efforts or potentially advocate for some that are more in line with our priorities and goals here. So I believe that's on schedule for March or April.
That's what I wanted to confirm. Is it March or is it April?
So in my conversations...
It's currently planned for March, but...
Yeah, in my conversations with DCE Campos, he thought it might be more successful if it was in April, just to give the legislative cycle a bit of time, but he was prepared to come back in March as needed.
We'll follow up with him offline then. Thank you.
Yeah, absolutely. So the one I did want to talk a little bit about, and certainly we have a lot of people represented here who may make additional comments, is number 10, which is to expand and formalize pretrial diversion. And I think this is somewhat of a moving target in the sense that every year it seems that we have come up with new and engaging and far-thinking, far-reaching ideas in our county. I think that's what many of us are very proud of the work that we've done. But a couple of things to highlight, I think, is we have pretrial services officers as an independent, the Office of Pretrial Services is an independent office in our county. And we have a very close relationship with courts, and we've had pretrial service officers in courts in the past and also into the jail. And really that's helped locally to speed up those releases, to make sure that people are safely being referred to diversion programs as necessary, and for those that need judicial review, that they're getting appropriate assessment. So of course our courts and our magistrates can make the best determinations for public safety, but also to ensure that people who need additional services are getting them. I think the two teams that I know we're going to have a presentation on, but I think continue to be really the forefront of some of the excellent work we're seeing from the collaboration between the Office of the Public Defender and the District Attorney, is the CAMP unit and the PAR teams. And so really ensuring that people who are likely to be released, who need treatment and supervision, they're provided that representation early, and that they're getting speedy access to services and release. I think Santa Clara County one of the benefits here is that we all understand that people who are entering our judicial system they're going to come back to our community. These are members of our families, members of our community. We want them to be healthy, safe, and well, and that behooves all of us if they're healthy, safe, and well. And so we've done really, I think, innovative work, making sure that they're getting access to those services and coming back into our communities, hopefully in a much more safer environment, but also ensuring public safety. And I think one of the current projects that we're working on, and we're going to be doing a little bit more discussion about this in various venues in front of the board and other committees, is a collaboration again between the District Attorney's Office and the Office of the Public Defender, behavioral health and the courts, and exploring an opportunity for further improving really access for those who may need mental health or substance abuse treatment, that they're identified early via a specialized mental health arraignment court. And that is something that we are still exploring. There's a lot of conversation and interest, and again, trying to move that representation, that access to servers earlier on in the process, so that those that are safe to be either in a supervision program or getting access to services are connected with those services more quickly, so that we can lessen the likelihood that they'll decompensate in a jail. And let's see. And Matt or Kavita, I'm happy to move on to item number 17, which I think is another important item, which this came up as, and I'll just make really brief comments on it, but it's how do we ensure that as we are looking at pretrial justice reform, as we are getting people out of the jail environment, connected to community services more quickly, how do we make sure that victims are also being identified? And this was really, I think, pointed out by our advocacy organizations and leadership of the board, making sure, and particularly domestic violence victims, are notified. So victim services changed their policies and procedures within the district attorney's office so that they work more closely with the assigned law enforcement officer and also the deputy district attorney earlier on in the process when those cases are being reviewed, so that victims are notified, sometimes pre-filing, about Marcy's Law, release and notification, the services that they have, how to get emergency protective orders and different restraining orders that they may need. And also Victim Services works very closely with the VINE, which is the state victim information notification system, to ensure that we're moving up that process and victims are getting notified as early as possible on some of those more serious cases to ensure their safety as well. So really, as we looked at pretrial justice reform, I think we've really done a good job of trying to consider the needs of what we sometimes see as two sides of a different coin, but really are much more closely related than that. The safety of our victims and also the safety of those entering the system, and oftentimes they're in the same family and they have some of the same criminogenic needs. So making sure that those victims are also notified too.
Go ahead, Matt. I was thinking number 12 would be a great one for you to highlight.
Thank you. Number 12 is really a joint effort, like every single success that we've achieved so far in pretrial. It's support through pretrial services and the Office of Reentry Services. Really, it's everybody. There have been a lot of changes legally, philosophically, and therefore operationally. One of the things that we were able to accomplish during the pandemic were really thorough reviews of the whole jail population. And it was interesting to see how the jail population has changed now from what it was before. So we really have mechanisms in place now that make it so that we're not, so that's not our only option. We have the PAR team, they'll speak more about that. We have pretrial services screening more people sooner. Also, administrative booking is able to work on cases a lot sooner. So all the processes have actually improved, either by speed or more earlier, and that's been really helpful. At this point, if we were to do a re-review of the jail population, we'd find relatively few people that would be pending a bail hearing, and they're stuck in jail just because they don't have money to pay bail. And when it comes to, it goes back up on, this actually ties into number 4 as well. Is that okay, Kavita, if I touch on that at the same time? Okay. So the judges are ordering pretrial supervision twice as often as they used to. money bail has gone down to a third of what it was. People who are on what's called a SOBA, which is unfortunately,
Matt, I'm going to ask you to say that again because it's so profound. I think you should. I just want that there be an exclamation point behind those two things.
with support from the very progressive Board of Supervisors, and I remember this 10 years ago, and all the justice partners, because it was my job to go around and get different points of view and try to gather information. And I actually remember the night before the publishing, it was Kavita and Laura Trice that rescued me and fixed the report. But anyway, since then, we have only a third of the money bail that we used to have as far as releases. And pretrial supervision is being ordered twice as often. If you count ORs and SORP, which is Supervised Own Recognizance Release Program, and then the kind of reactive service of Own Recognizance Release, ORs, we have about 5,300 cases right now. It's a significant increase. Back then, it might have gotten to about 2,000 total. So that gives you an idea. I wanted to get back to the people who used to be ordered to money bail and pretrial supervision, where pretrial services is really providing the supportive services through Office of Reentry and many of you, and they also have to pay money. I looked at it this morning, it was 0.077. It's less than 1%, the releases. To see how many are in jail because of that, it's hard to tell because it's very dynamic. They pick up other problems in other jurisdictions, and they might be serving time and things like that. But it's less than 1%. So those are significant concrete improvements that are obviously, you can measure them because we just did. So.
Thank you.
I think nothing else to add affirmatively. We'll just be happy to answer questions about any other specific items you may have.
Okay, I'm going to take public comment. Greta, do you want to speak before I go to public comment?
I just wanted to say one thing, which is more of an editorial comment, but you know, I think I was glad to see the bail and release work group's work get re-agendized and for staff to put this together because I think this chart really demonstrates kind of the breadth of items that came forward, and also, although there were many other efforts that were parallel to this one that really moved the ball forward, this one was a really significant effort that brought a huge number of county stakeholders together, got really in-depth feedback. The meetings took place in this chambers. They were there was a very deep commitment on the part of county leadership to staff this committee and a really methodical process to bring forward to the board recommendations for consideration and approval. And I would just note that the board also did a lot of work on this item and considering point by point the recommendations that came forward, did not approve all of them, did approve most of them, and then also supported the investments necessary to bring those items to fruition, several of which took a few years then to actually see all the way through, given the complexity of what was undertaken to manifest into programs or other services, those recommendations. And so I also just feel like, you know, big kudos to Matt, who was one of the primary people in his first role in the county who staffed this work, to Kavita, to Laura Trice, and to James, who's the deputy county executive at the time, who oversaw this effort from a county administration leadership role, in addition to the really intensive engagement and support from the board, including making sure we had the right committee members brought together. And that included members of the bail industry as key stakeholders in engaging these questions, and sometimes also not being able to answer some core policy questions that also was, I think, illuminating too. So just wanted to add that layer.
Thank you. Thank you for that, and thank you in yet another area, Supervisor Chavez, for leading in such a dramatically impactful way. It really is exciting to hear this work. I see that your light is on. Would you like to speak
Oh,
before?
the public first.
Okay,
Yeah.
public first, then I'll come to you, and then I have a few questions. Do we have public speakers?
We
in
have
chambers?
one request to speak online, none in the room, but the request we have named resident. Please accept the unmute. You'll have 2 minutes to speak, and the timer will start when you begin speaking.
Yes, hello. I'd like to thank you guys for coming up with this great report on bail reform. I mean, definitely using a nonprofit, that could really help the community and help people get out of jail who shouldn't be in jail. I mean, for profits usually, they don't take the people into consideration. Like if I can give you an example, my former attorney, as I mentioned before, I mean, she's sex trafficking my kids. And if I had known that the county would have this kind of a reaction, which is gaslighting me for complaining about this, and also filing charges against and trying to get the matter moved to competency proceedings. I mean, there's no way I would have moved my kids to this county. I mean, the way that this county treats children is just it's shameful. And you guys are giving each other kudos, and it's impactful and it's amazing and it's great and it's this and it's that. I mean, it's just all meaningless if you guys let my kids just sit there and be raped. It's just completely disingenuous, everything you guys are saying about bail reform and everything else about this county and protecting people and all this and that. I mean, you guys right now, you guys could pick up a phone and get my kids protected, or at least get an evaluation done. You guys refuse to even do that. I mean, it's shameful that I have to come to meetings and I have to uh, file lawsuits against the county to get you guys to do something. Just terrible. Thank you very much.
And that concludes our request to speak.
Supervisor Chavez.
Yes, thank you. I have some comments about the product before us, but I wanted to start out by just telling a little bit of background about how this got established. And I think the reason it's important is because this was actually born out of conflict between members of the Board of Supervisors and our district attorney, Jeff Rosen. And the reason for that was we were having a debate at the time about how we handle people who are undocumented and in custody. And the reason I say that is that what started as a conflict around this very basic question, which is how is it that we keep people who are dangerous to the community in custody and people who are not dangerous to the community, giving them the access to deal with their legal issues outside of custody. I mean, that was very simply the beginning of it. And we made some mistakes. As a matter of fact, the bail industry was added very late in the process. We had advocates, we had members of all of our teams. So I say that only to make 3 points about that experience. One was that if you had walked in the room on the last day of our meeting and heard any member of the committee speaking, and they did not have their department name on their placard, you would not have known what department they were from. And I do think that speaks enormously highly to the professionalism of the county, because what it demonstrated to me was that the county leadership, our administrative staff, were willing to use data to come to some consensus around how to proceed. And so I think one is, I just wanted to say how much I appreciated that. So first, conflict can actually be really good in terms of having good public policy products come out of it. Second, just deep appreciation for all of you. And third is that we had a lot of consternation and concern from the community members of the board around how we would concretely measure success. What were the initiatives that were going to come out of this and whether or not they were meaningful? And I will be frank, not everybody left that happy, which I also think was okay, because the outcome of that was to be much more rigorous in our assessments of each of the actions that we took, which I think is exactly what our job is. And I really want to appreciate, there are a couple of people, I think Matt was amazing. I also just wanted to highlight David Angel, who's not sitting with us today. I'm sure he's off doing work somewhere else, but I mean, he works for the county still. But my point is that I thought what he really allowed for was creating the space for good debate. And Kavita, to you and Laura, they were very disciplined. They did not get stuck in hyperbole. They were looking just at the facts, and that kind of just discipline is so rare and so incredibly helpful, especially when something as emotional as this subject is to the public. It was very hard to stay focused. So I just wanted to say, I think this is so going in the right direction, and I really, really appreciate the leadership of this organization, and also to Senator Cortese, who's not here, he's busy being a senator, but he was very, very, played a big leadership role in how we proceeded. So just to go to some of these items, I do have, I want to say, Susan, thank you so much for bringing this back, because actually having an annual check-in is very, very important. And one thing I would recommend is that I think there would be value in annually or biannually doing some interviews with our key partners. And I want to just give you two areas that I think still need some addressing. One is that our partnership with the courts is so critical, and I continue to get feedback from the courts about a concern around how much information we're able to give our judges at the time that we're asking judges to make decisions around whether or not someone is detained or not. And what it appears to be is a combination of, well, actually, I shouldn't diagnose the problem. I'm just giving feedback on what the judges have told me. They love pretrial services. They've appreciated with youth working with probation, but I'm not yet understanding how we make sure they have all the information they need, so that if in fact somebody is a danger to the community, that they are given the assurances that they have the information they need, or even if they're not, to make a solid decision. And I don't know if that's anecdotal, and Judge, I don't want to put you on the spot, but I'm not sure exactly how to get to the root of that, except it seems like we need a little more work done to affirm that you're getting what you need.
Your job is to put me on the spot, and that's why I'm here. So I'll always do the best that I can. I will say this, first of all, the law has changed. There's case law now which requires the court, for every case before it, to consider financial information in determining money bail and whether to proceed with money bail. When it comes to the information that the court must consider, we only have a couple of choices for getting that information. It's usually the defense attorney or it's pretrial services. Often, the defense attorney does not meet the individual until they're at arraignment, which is why all of the PAR work now is so important, because a judge can only make a decision based on the information presented. I can say that statewide, bail continues to be a very visible topic. Los Angeles, as you know, has made some changes based on lawsuits there. Our county, me personally, are the subject of a lawsuit here, so there's not much I can say about that particularly right now, or my attorney will say that that's inappropriate. All I can say is the best we can do is to have as much information as possible, because the law does now require a case-by-case, individualized assessment around bail, if that's helpful.
Yeah, thank you. And I would say that that we should be giving some direction, Susan, that the next body of work really has to be diving into that question. And there are a number of reasons why I think it's important, but one of them is that even when we brought forward PAR, which we sort of stole from San Francisco as an idea and then customized it really, our public defender, Molly O'Neill, had her own, like, wanting to, in a good way, shaping it so it matched our county. I do think that that we just need to look at those systems and processes a little better, because I think ultimately our objective is to have the safest community we can by protecting civil rights in equal measure. And those two challenges, they tug on each other, and I know that, but I think making sure that you have the information you need is a really critical issue, and it's come up from way too many corners for me to think it's just a one-off issue.
Can I follow up on that before you continue? I was going to turn to Public Defender O'Neill, but if you're leaning in to address that, my question is really what percentage of defendants are still appearing where they are meeting their public defender for the first time at arraignment? I thought we had really would significantly reduce that. Should I go to Molly first? and
Well,
then
I
go
was
back
going to
Fred?
actually just follow up on one comment from Judge McGowan, and then maybe I can pass it to Molly. I think I think it would be good for us to come back and address what is the information that is coming from various county departments to the court as they're making some of these decisions. But one thing I wanted to highlight that Judge McGowan also highlighted is this is still an area where the law is evolving really significantly, and there's sort of different ways to solve the information challenge, some of which has to do with just what is the general approach taken. So Los Angeles is now back in a $0 bail scenario. So the court in that structure doesn't need a lot of information about the defendant's particular financial situation quite in the same way as they would under the structure that we have now. So I just raised that up to say it might be good for us to kind of come present a picture of kind of how much what is in flux, what's not in flux, and where are the pain points where we are today.
And I should have been more specific. I'm so glad you responded to that. I'm really talking about what the history of the defendant is. That information, that from talking to the justice or the judges, that it has felt very inconsistent to them and not complete. Yep. And the problem with that is that for us, we're using all of these tools to determine under what circumstances can someone be safely released. If we're not able to give the proper information, the approach we're taking may or may not be the right one. And I'm particularly worried about that when you have defendants who have a history of violence, and the most recent crimes may not be violent, and then it puts a judge in a situation where they're making a decision about releasing and how to release and what's the best environment to release in. Is it SOR, whatever the program is. I want to make sure they have all the tools they need to be bold and make good, sharp decisions. So not so much on the finance, I'm much more concerned about having a more complete and rigorous record. And some of the concerns I've heard is how much time people have, how much room is on a form, and some of that sounds like things we can fix, right? And some of it may just be timing. So that's why I think if we could do a deeper set of interviews, I won't be guessing, and the board won't be guessing about what the tools are that you feel like you need, and especially because now we have a little time under our belt. Like we're learning, and I think that's actually where we should be now. But thank you. I should have been more clear what I meant by that.
I appreciate that direction, though, and would ask you to incorporate that into a motion.
Thank you.
Thank you. Molly.
It was a long time ago, but I think the question was how many clients are being seen by our PAR team prior to arraignment, and roughly half now. We've scaled up. At first it was only 25%. Excuse me, and the goal, of course, is to get to 100%. We would love that. Early metrics are really positive, but one thing we do is provide a whole lot more information to the judge because we're speaking to clients earlier. We know more about their job history, whether they have some place to live. Obviously, their prior criminal history is in play and is communicated and asked about. So we are really proud of that work, and we do think it would be, and let me back up and say, the PAR team really, because of you, Supervisor Chavez, grew out of this bail and release work group, and we have had multiple jurisdictions come to get trained by us to look at it, including LA, San Bernardino, and we do have Megan Piano, the supervisor of our PAR team, and Charlie Hendrickson, the assistant who oversees it here. If there are other questions, but roughly half, and hopefully more than that soon.
Thank you.
Thank you.
Matt, and then Judge McGowan.
Yes, I would just suggest two concrete items that would significantly help and immediately would be to continue to support the PAR team because they're truly doing a triage. They're trying to get to the people that they believe they can help the most. It's most impactful for the court. Pretrial services is also triaging. And not all the defendants upon their recent arrest are ready to be interviewed. Sometimes they're not coherent. Sometimes they have a medical issue. Sometimes they're not cooperative. And the jail is extremely efficient and is able to whisk them away to Elmwood. If we could staff Elmwood, if we had the resources to staff Elmwood, we wouldn't be under such difficult time constraints. These small windows of time to interview people, and then you try to verify the information. And it's between all these different activities, but it's difficult to staff because this is a 24/7 operation, which doesn't just include pretrial services, but really all of us. The judges are available through the county comm 24/7. So,
Interesting.
Thank you for that, Judge McGowan.
Right, so let me just briefly touch on LA because I think it's illustrative. The court always compares itself to the other 7 or 8 large courts in the state, and we model ourselves. The lawsuit which resulted in 0 bail for Los Angeles is very similar and in some ways related to the lawsuit pending against our court in this county. Let me start by saying right now with 0 bail, the information the court is interested in is the financial information, and that's what PAR and others are gathering for us. In Los Angeles, by contrast, right now, when you're not having money bail, instead you're having detention hearings. So the first thing you should know is that more people are being detained. And that information is a different set of information where the court's now asking for. Instead of the financial information, the court's much more interested in LA about whether other past citations might have included violence, whether there are any out-of-state or out-of-county, other county citations that have to be researched. So it's just the topic of the information has changed for 0 bail, and the outcome has actually been an increase in those incarcerated because the detention hearing usually leads the judge to err more on the side of detaining while some of these things happen and the person becomes more amenable. But since it's not a money bail determination, it's now a determination based on all these other factors related to the county. So I think it's a fair point to make at this point that you're going from the focus on the financial information to a different focus on the history of the individual, the type of citations there have been in the past, and whether detention is appropriate, even if for the short term. Judges always want more information. We want to make the best decision we can. So that's the only point I wanted to make when comparing with Los Angeles.
Can I?
Thank you so much
Can I
for
add
that.
just one more thing to that?
Go ahead, Sylvia.
So I think following up on all of those points, the other thing that has changed dramatically is obviously the responsibility and the number of cases that pretrial services manages in comparison to the caseload pretrial service ratio, pretrial service officer ratio. But one thing that's changed too is that we don't have as many pretrial services officers in courtrooms as perhaps we did before, and that the combination of that there has to be an improved relationship between the judicial officers and the pretrial services officers. Because as advocates, defense attorneys, we can say all these things, we can fill in our perspective, we could be the advocates to fill in the void. But the pretrial services officer is a county employee with an opportunity to have an incredibly powerful relationship with a judicial officer because you serve such a neutral role. But when we don't have pretrial services officers that have had that relationship with the judges, sometimes, and I know, I get it, I don't want to put you in the spot, Matt, but it's a change and it's in a point of transition. So in my experience in the past, when we had a pretrial service officer in Department 23 doing arraignments, and that pretrial service officer was in connection with the needs of what the judge needed. They were like, I know that this individual, after a detention hearing, where the judge is inclined to detain, but if the pretrial service officer can say, look, I understand your concerns, Judge, but I support, the defense attorney's request, electronic monitoring may be appropriate and suitable. That may meet your concerns for, community safety. Or, we verified this information that the judge or that the defense attorney is mentioning. Or, yes, that is correct. That other community-based organization does provide this service. In other words, I get the issue that you've raised, Supervisor Chavez, because I think it's a legitimate issue, and I think it can be addressed with, and I know it's a staffing challenge, but it has to be that judges have to feel comfortable and confident in the objective information they are receiving in the courtrooms. And that, sometimes it will be in our favor as defense counsel, but sometimes it may not. But most of the time, it'll be because they trust the information they're receiving.
And I know, I want to make sure my colleague has, oh, Matt, do you want to weigh in on that?
Ever so quickly, I'm happy to say we've resumed court as of today. So at least virtual court appearance at the Hall of Justice, so in Department 23 and the family violence. Something we're very grateful to be able to do, and it's a big stretch. We've had to prioritize pretrial supervision and the family court reports backgrounds that we do for those restraining orders. And so I just want to emphasize one point that Sylvia makes. The judges need to be able to trust the information they get. It needs to be as verified as possible. And if it's not strong information, a confidence level should be shared. It requires a high amount of training to go into the courtroom. Really, it needs to be the officers that have worked in the jail and have worked in pretrial supervision to be able to answer all the questions. It takes a couple of years to get that training, and we'll get there. We'll get there. But thank you.
Thank you.
I'm going to just make two brief comments because I want to give you, Susan, I'm so grateful you put this on the agenda. I want to give you a chance to ask your questions. Here were the two recommendations I wanted to just make, in addition to the ones we just talked about in terms of doing a deeper dive on information. And one thing I would be really interested in understanding is how we do get to 100% relative to par. I just think that's a concrete thing we need to understand and know. But two recommendations I wanted to make. On the feasibility of the nonprofit alternative to commercial bail, I do, however small that group of need is, and I don't know what that will look like in the next couple of years, but one thing I think would be of value is to actually change number 2, to take a look at doing an RFQ instead of an RFP, but an RFQ for a partner organization that could assist us in a broader set of activities to help people pay down debt, even for paying, is it retribution? Am I saying that right? Restitution. Jesus, Cindy. Opposite. Okay. So, but for restitution as an example, because there's a lot of really great national work being done to help folks of modest means be able to meet their obligations through a more structured payment. And I think we just need to do an RFQ instead of an RFP saying this is what we want. I think we need to identify the problem and see who would like to partner with us to help resolve it. And it actually speaks to an issue that you were raising about young people too, because I think it may be a way to allow young offenders or even first-time offenders who do something significant to have a path toward addressing the crime they've committed, having a more community-oriented way to both meet the needs of the victim and the person who's committed that offense. So anyway, I would recommend that be an RFQ. And then on the last issue, there are a number of areas here that look at ODARA and other tools that we have. And I do think there could be value, Susan, to maybe biannually looking at the assessment tools that we're using to determine the efficacy of them. I know that's done internally, but it's not a public discussion and may be valuable to do at some point because, frankly, I think it will put more eyes on whether or not we're using those tools properly, effectively, and under some circumstances, whether or not we need additional tools. Because, for example, when we looked at ODARA initially, there was some concern about layering tools. And I think where we're learning and we're talking about human behavior, that those tools actually help us refine long-term how we're going to do a better job of supporting all members of our community. And again, it was a little bit, people fussed a little bit about that. An extra tool, and yes, we needed an extra tool. But I'd like to understand how effective it is. So I want to give you a chance because I know this is an area you care a lot about.
Thank you. Kavita, did you want to comment on Supervisor Chavez's last recommendation?
Very briefly. So I would defer to Matt to comment on the assessment tools, but very, very briefly, a technical point on the nonprofit alternative to bail bonds. I think I understood what will become a motion. The technical point I had is, from prior experience on this issue, sometimes an RFI, a request for information, is the right tool versus RFQ, so I would just love to have flexibility at a staff level to determine that, but definitely understand the point.
Excellent point, thank
All right, thank you. Thank you for the history. It's really an honor to sit on this committee, given all of the work that has been done in the past, and have the opportunity to continue to build on that. Really, what it says is that this board has a long history of commitment to justice and criminal legal system reform, and I think that's just a tremendous legacy to be a part of. So I am glad to play my role for the next years going forward. I have a couple of specific questions, just a few about some of the recommendations, much more micro focused. Regarding recommendation 7 for the credit debit payments, just who's leading the re-review process of the legal and vendor landscape on what approximate timeline? And is there any opportunity for overlap with whoever we're looking at for RFI?
I'm happy to respond to that. We haven't initiated a re-review process. We can certainly do so. This was such an interesting and frustrating one that this felt like it was going to be one of those low-hanging fruit. Why don't we just stick a credit card machine in? And for those people who don't carry $1,000 in cash but could put it on their card, wouldn't that make it a lot easier? And it turns out the regulatory landscape for offering credit card processing services in this area is so technical that there are only a couple of servicers that do this, and they do things like require the sheriff's office to agree that the person can be rearrested if their payment defaults. I mean, things that are just very inequitable. So I think we need, if we were to return to this, it would require just a whole resurvey of the vendor landscape, which wasn't looking good back in 2018. But there are a number of vendors that I know the county uses for credit card processing to accept things like property tax payments. The sheriff's office uses them to accept commissary so that family members can put into commissary. So those could be worth looking at just as starting points.
Thank you. Then I would like that to be revitalized, please. Thank you. Regarding recommendation 13 to incorporate pretrial justice issues into ongoing data systems updates, are pretrial justice issues being incorporated into the JMS project, or should they be if they're not? Is that for Matt? For who should it? Who?
Well, I guess I would say part of the broad replacement of CJIC includes the full spectrum of criminal justice technological infrastructure. And so I don't have a good understanding of exactly what the same command that maybe others on this panel, but certainly the TSS staff working on this would be able to say, here's where one system picks up and the other ends. The organization of what will be the infrastructure to replace CJIC will be different than CJIC in that it has various freestanding components, but that talk to one another well, as opposed to one mega system that's a little bit more unwieldy. And so I can't answer the specific question of how many of the pretrial justice workflows that need to exist in that broader system fall under the component that we call the JMS versus fall in one of these other components that talk to JMS. But certainly pretrial justice elements are part of that broader effort to replace the CJIC data system, but maybe Matt can speak to that with more precision, or Casey.
Yeah, most simply put, yes, absolutely. That'll be part of it. We all work together. The areas that they're working on right now don't involve that. They're more the administrative parts of the jail. So we haven't gotten there yet. I can't take credit for doing much yet.
That's okay. As consistent and in support of Supervisor Chavez's recommendation that we bring this back on some cadence. I think we look at this as a work in progress, and every time we come back, we have an opportunity to review where we are on the recommendations, what in the law has changed, and what are best practices of the moment. With this, okay, let me move on to a different one here. I don't want to wait for 2 years. I'm thinking, as I said that out loud, that feels like a long time to get an update, and I assume the the new management system will be in place well before that, right? Yes, in June. So perhaps that could be answered or addressed in June?
Yes, I think we could come back with that.
Perfect. Thank you so much. That feels better to me. Recommendation 15 is to improve consistency of citation and release and jail citation decisions. The status and next steps to me felt a little bit vague, or I just didn't understand them well. Our county, I've heard that our county has a policy that allows for release for offenses on the bail schedule below $15,000. Is that a factor that contributes to consistency in the county? What other factors contributing to consistency should we be working on?
As recently as this morning, I looked at the data going back 5 years, and the number of citations is really flat. It's remained consistent thanks to the cooperation of the Police Chiefs Association. They actually have an agreement, a policy, if you will, about the $15,000 threshold, with some exceptions that just make sense, like domestic violence. There's some discretion, but very little. Mm-hmm. And peace officers express that, utilize their discretion as they work with the Sheriff's Department during the booking process. Honestly, the rigors of the pandemic really helped to streamline the citation process. That's what I've noticed.
Great.
And so I don't know that there's a whole lot that could be done there, to be honest.
Okay, I appreciate that. Judge McGowan.
Let me also add that the law requires every superior court in every county throughout the state to adopt a bail schedule annually. Mm-hmm. Our bail committee has made a proposal. The committee's vote was unanimous, unlike last year when it was very divided. And the bench as a whole will take it up at the bench meeting on January 30th. And from that schedule, we know what's set at 15,000 or below, although each municipality's police department might have slightly different cite and release determinations. The court tries to uniformly apply the bail schedule as adopted. And of course, at the next meeting, I would be able to report what our bail schedule is.
Thank you. I think that would be a great time to hear the report and to see if we have further questions. I did anticipate this being sort of maybe the most robust part of our meeting. We're an hour in, though, with 3 more items. So what I would like to do, unless anyone has an additional burning question or comment, is vote on the motion that incorporates all of Supervisor Chavez's direction, and I think I added a piece or two, so I will second the motion. We've heard public comment. Colin, let's vote on this item, please. Oh, of course.
Can I just read into the record where I think we are?
Please, that would be
excellent. Just to see if we're tracking. Mm-hmm. So one is that we do have a biannual report to this committee about the work continuing to happen, except where the committee asks for a specific report out to occur on a sub-item. That with the future reports that we include an update with the chart with the owner of the issue area and also the timeline as it relates to next steps. It would just add clarity. Mm-hmm. That we get a report back at a meeting to be determined by the chair on what would be necessary to get 100% to par. That items 2 and 7 be reviewed for RFIs and whether or not they can be combined. And I would recommend we look at vendors who manage and do support work on debt, and that include youth for also to be able to pay off fines, and also that we get an update off agenda on pretrial service availability in the courts. And Matt, just to say, not to put you on the spot, but what the delta is in need in terms of staffing when that off-agenda report comes back. That item 13, that we have a report back on the incorporation of the pretrial information in the new system by June. that item 15, this is the consistency issue, and I would like to recommend that there be a report back to this board at its most appropriate and earliest opportunity to both look at engagement of the chiefs of police, training, and to better understand the differences between the way each city handles this item. And one recommendation I would make, with the addition of Chief Mata coming over to the district attorney's office, that the district attorney's office consider whether or not it makes sense to have that ongoing item on the chief of chiefs agenda, just to recommend that, so that we have a better connection between the county's work, the court's work, and the departments, because I actually think that inconsistency is more significant, because I don't even think it's department by department. It could be shift by shift in terms of how people are adopting it, depending on the size of the department. And that would be our motion.
Thank you. The two additional pieces would be the report on the new jail management system and how we're incorporating pretrial. Did you say that in there?
Yeah.
Okay.
Yes.
Thank you. And, the other is the PAR issue that you raised regarding getting us to 100%. I think we need to look at that somewhat quickly, because there may be budget implications, and I want to make sure that we're not moving full speed ahead here with policies for greater and earlier and more complete representation, and then impacting the public defender's budget in a way that is counter to that. So
Do you want to have that come back in March for a discussion then, before
let's do
budget?
that, because
Okay.
February we have the joint
Yeah.
meeting. So we'll bring that in March. Does that work for the public defender?
Yeah.
All right, thank you. Greta?
I just wanted to note that we, two questions to perhaps incorporate in the motion, depending on the answer. One is, as you know, we're going to be bringing forward a number of items whose origin was the Alternatives to Incarceration group, and we had envisioned a similar reporting format to the one that we brought forward here, and I heard Supervisor Chavez's suggestion on a couple of other columns to add to that. But because there are some items on this bail and release work group matrix that are totally completed, implemented, and sort of ready to probably not be the subject of further reporting, but a bunch of other things that are coming forward as part of that Alternatives to Incarceration work, which will be probably initially discussed here and then need some action by the full board.
Right.
I wondered if we might be able to align the structure for reporting, and perhaps actually consider delineating the origin, but having that eventually become one body of work, so that the reporting is aligned, the structure of the items is aligned, and especially as we take a bunch of items off the list from bail and release work group as they're completely done, we then can align what is the remaining bail and release work group that feels very much aligned with a lot of the ideas and vision that was discussed at Alternatives to Incarceration.
I think that's an excellent suggestion, and I think there will be a lot of public appreciation of a similar structure to this, with the recommendation, the party that's responsible, the next steps. I want to make sure that it includes all of the ATI work group's recommendations, including with notations that something is not in the county purview or can't be done, just to indicate that we are considering everything. And when we remove items, which I think is a great thing to do, I'd like to have at the end of each report just an index of items that have been completed. So if there is any question about why did something fall off the list, we can easily look and say, oh, right, because that was done.
And I might add, I think that's exactly right. I appreciate that. And the other thing I'll add about that is that sometimes while we're fixing one thing, we actually undo another. So having that chart is actually going to be, the indices of what has been done would actually be helpful, because I do think our best thinking is when we can combine what we're learning with what we've tried and maybe what didn't work, and even things that we decided not to do that may pop up and be more viable. And I think the point that Judge McGowan raised, and actually, Kavita, you started the conversation by saying we were working on things while the laws were changing. And I would just say that one other recommendation I would make to the next cover memo would be to actually talk about what's changed over the course of the time that these bodies have been working. Because I think for people who aren't looking at this all the time, I just think if they're reading it and say, oh, that's why we're not doing that, it would save a little bit of confusion. And frankly, it starts to help us heal with distrust because people understand where we're going and that we didn't leave their ideas behind. Yes, that's great. Thank you.
Thank you. And just a timing issue, are the ATI reports, I think we have things coming back in April and in August?
Correct. That's at least the schedule to date, so we can.
So which one are you thinking about for?
I think
formatting?
maybe if we can just give some thought to taking a look at this matrix, how much progress we may have to report. But I think we could just we can try in April to bring back what would be essentially a combined matrix that delineates the origin of the recommendations. If not, we'll at least be reporting out on all of the ATI work group recommendations, including which ones we think also need some further action by the board to move forward.
Outstanding. Thank you very much.
Thank you.
Let's vote before there's another brilliant idea.
Vice Chairperson Chavez.
Yes.
And Chairperson Ellenberg.
Yes.
Motion carries.
Thank you very much. Item 5 is the 2024 PSJC work plan that I just want to say a few things about, and I think that this will be ultimately a brief item. You've often all heard me say how appreciative I am of the unique opportunities in this committee to bring together really diverse expertise across our very interconnected, yet sometimes still siloed work. So it's with this in mind that my goal for the work plan is really to promote transparency and collaborative iteration among all of our stakeholder agencies represented on the dais, as well as to follow up on issues that were raised in past discussions that warrant further study. The brilliant, really, I'm so grateful to learn from all of you, all of the experts on this dais on how we can accomplish that collaboration. So I would look to any and all of you for feedback on the proposed work plan, any desired outcomes from proposed discussions or additional topics of interest. So I'll look for any feedback first and then kind of wrap up with some comments, final comments.
Thank you, if I may.
Please.
I just had a comment about the combined public safety meeting with the city of San Jose. We previously requested some data from the city of San Jose related to the high utilizer group. We're doing our own kind of deep dive into our frequent flyers, but I think it's really hard to have a conversation about conclusions and deductions related to who's in and out of our jails and in and out of the system if we don't know who we're talking about. So I would just ask that if at all possible, we have that information before that meeting and discussion takes place.
Fair enough. I will ask Auden on my team to follow up with the city and see what the status of that is and if we can get it. And I would encourage and welcome you to advocate for that as well. Thank you. Anybody else up here? Sylvia.
Yes, thank you. I think your objective for the work plan is very good, and the timing is great because I think we're all in situations where we have a lot going on, and yet there's a demand for a lot of our attention, a lot of our time, and the collaboration is incredibly important. And the absence of siloing each other's work is sort of a very old thing now. But I wanted to just highlight and thank the Sheriff's Office for their leadership and their willingness to collaborate with us with some of our needs that are really impacting our practices in the courtroom. And I think, the transportation issues we're having, any challenges with getting attorneys in the jails and therefore moving their cases in the courts, that's one example of where I think there is a lot of opportunity for us to work together because we are so interrelated. I know there's staffing issues at the sheriff's office, but with, I think, improved communication, we can deal with. So I just wanted to say, yes, that's a great ambition, it's a great goal, and I think it can be done at various levels. There's a lot of work we're doing with the DA's office and trying to handle really, really challenging cases. And there's a lot of work behind the scenes that nobody sees, but it's happening. And it really can have an impact as we're all struggling to survive in the challenges with the backlogs and court operations and our internal staffing issues and budget cuts. So I applaud your plan, and I hope that we can implement some very concrete things.
Thanks, Sylvia. Javier?
I'm excited about the item restorative justice study session in
you would be.
September. I know that was an item that was brought up by the HEI work group. And as we're looking into other AB 109 models from other counties, Santa Cruz County has a restorative justice for adults. So we could basically look at all the models in the state that can benefit it. I know that we have a meeting in South County tomorrow to talk about the South County Youth Task Force, and the DA has been very successful with probation and the public defender in implementing a restorative justice program for youth.
Fantastic. Thank you for that. And certainly in advance of the study session, we will work with you as well as the rest of you to make sure that we are incorporating whatever best practices are available, any resources that we should be looking to so that we can have a really meaningful study session and conversation. Thank you. You may notice that there's an identical meeting agenda item in April, August, and November. Those meetings will be dedicated to discussing plans for a new jail design alongside reports on the progress of alternatives to incarceration and diversion efforts. In addition to the quarterly ATI and diversion reports this committee has received in the past, we're going to be looking at the developing implementation plan for the recommendations, as Greta mentioned, from the 2021-2022 Alternatives to Incarceration work group. That's the 37 recommendations that we referenced earlier, and that's all I wanted to say about it. Do you have something else? Oh. I will second that. Do we have public speakers on this item?
We have one request to speak online.
Okay, specifically related to the work plan. Terrific.
This is, next speaker is named Resident. You'll have 2 minutes to speak, and the timer will start when you begin speaking.
Yes, hello. I mean, there was one other item that I think that we could add to this work plan, and that's sex trafficking. If I could give you an example, when I reported that my kids were being sexually abused, at that time I was dealing with another mother. I have a child with her, a girl, and I've been retaliated against. I went to court, and right now this girl is under the legal custody of a man who previously drugged and raped a teen. And there's evidence of it, and it was submitted to the court. And that guy could easily just kidnap her, take her, because he has legal custody of her. And so the mother knows this, and we went to court, and she agreed. She agreed that I should have legal custody, so it should be split. And before we could sign the stipulation, the mediator, she rushed us into the courtroom, and the judge acknowledged the memo from the mediator by referring to the waiver and defect of service. So she agreed. She had all the evidence, and she denied the motion. She did not give us the right to come to an agreement between the both of us, because nobody cares. Nobody cares about children in this county. And really, it's just a travesty what's going on in this county. It's not just baby Phoenix. There are other parents that I've spoken to who are going through the same exact thing that I'm going through. And you should really just post this on the website. Say, this is how we treat children. And then people will know. They'll know not to move to this county. Thank you very much.
That concludes our request to speak.
Let's vote on this item, please.
Vice Chairperson Chavez.
Yes.
And Chairperson Ellenberg.
Yes.
Motion carries.
Thank you. Item 6 is the quarterly inmate grievance report. Welcome.
Good morning and Happy New Year, Chairperson Ellenberg, Vice Chair Chavez, and esteemed committee members. This is Lieutenant Joseph Nguyen from the Custody Bureau Sheriff's Office. Next to me, we have Lieutenant Jose Quintero from the Custody Bureau Sheriff's Office. Next to him is Anu Paramatam, CHS Quality Improvement Manager and Staff Development Chief. Next to her will be Laura McKay from the Sheriff's Office. She's Custody Bureau Business Manager. Also included are our panelists. We have Hope Cooper and Katie Cummings from the Moss Group. Together, we have submitted our quarterly joint report of the Sheriff's Office, Custody Health, and the Moss Group, and we're ready for questions.
Thank you. Let's go first to public comment, and then we'll come back to the board for questions. Colin, do we have public speakers on this item?
There are no requests to speak.
All right. Look to Supervisor Chavez. Do you have questions on this item?
I do, thank you. First of all, thank you. This gets more and more comprehensive every time it comes forward, so it's much easier to understand, much easier to understand, period. So I have just some very broad questions about this. One is that in the report, it says that for third quarter of 2023, 92%, almost 93% of all submitted grievances were answered and returned to the inmate within 30 days of their submission date. And I was wondering, is 30 days our goal? And if it is, why? And if not, what would we be shooting for? Maybe not today, but in the years to come.
I will answer that for you. So 30 days is our timeliness objective, our goal. We do report that on our measures of success for Santa Clara County as well. Most models out there are 30 days or less. In our findings, if we do have a complaint that is simple in nature or emergent, those will be addressed immediately. We will not wait till 30 days. 30 days is just a timeline for us to receive the complaint, lodge it into our tracking system, ACES, and route it to the appropriate business unit if we have the time frame and the flexibility to do so. It also gets reviewed back by the Sheriff's Office Grievance Unit Management Analyst Civilian staff to ensure that the response is appropriate and meaningful, and also provide a conclusion for the complainant as well. So 30 days really give us that flexibility to really wrap it up in a bow, per se, and provide it back to our population.
One recommendation I would want to make, and you could let us know if this is something that's possible to do, it does appear to me that there would be a benefit in understanding what departments are we able to resolve issues in a more robust time frame versus other departments. And part of the reason I'm interested in it is more understanding how quickly you're able to take the recommendations you get from those in custody and I thought you did a really good job of explaining even changes that you've made. Like this was, and I think honestly, every report we get should have an analysis, numbers, and then next steps. And you really are moving in that direction, so I want to say thank you. But I do think that there would be value in understanding what departments it's easier within the custody to move more quickly, why or why not. And I also thought being able to pull out where you may have one person who's doing a lot of grievances really makes sense, because and I would just say this to all of our staff as you bring reports, the total number of activities is very relevant to the total number of people, because in some instances, as you pointed out, like I thought it was important to say, oh, the heater wasn't working in this department, we got a whole flood of grievances. Important to know. Also important to know how quickly were you able to resolve the issue, and then that group gets into the 48-hour We got complaints, we resolved it, we moved on. That tells me a lot about fleets and facilities being responsive to you and also your ability to handle, because I know whenever you have, you're moving people in and out, that you have to move those who are in custody. So I would just encourage you to dig in on that a little bit. And then also to continue to break out the reports where you have outstanding, like where you might have one person that's has 100 grievances, and then the average grievances for people who are in custody, what that looks like. Because again, I think one challenge for you is that your numbers will get thrown off relatively quickly, and it doesn't really share how much improvement you've made in terms of your ability to respond to those in custody, which I think you're really trying to do. So anyway, those are just some thoughts. And then one question I had about, and I'm glad you're reconvening the inmate feedback group. What's it called? Oh my goodness.
The advisory council?
Yeah, thank you,
Okay.
advisory council. One question I have for you is, does the advisory council look at the grievance reports with you? Is that something that's on their agenda?
We haven't shared a grievance report with the council yet, but the next time we do meet with the council, we do have an agenda. We do track. We do put the meeting minutes back out to the committee, the council, and when we do the next IAC, we will revisit all the items that were previously discussed, the steps that were taken, and all the progress we've made.
So one thing I would recommend is, I think there would be value in actually presenting the same report you're presenting to us. I think it would be really important to get their feedback because, again, in it, you list a lot of actions that you took actually in response to people who are in custody, like the changes that you've made to the commissary, those kinds of things. I just think it's meaningful because I think it demonstrates that you're listening to the folks that you're serving. And ultimately, part of helping people not recidivate is building confidence, building trust, having, giving people the experience of actually having been responded to and heard and all of that. And frankly, I think it allows us to do a much better job of providing the services we need to provide. So feel free, I think these are all public documents, right? Anything in the public record I think would be of value to share. And then I have one last question that Supervisor Ellenberg and I know have been really interested in this, and that is on the medical service grievances. It's still a little unclear to me about how those grievances, in fact, Dr. Luna, I may actually just ask you this question. I am really interested in as we're rebuilding custody health, what our targets ought to be relative to the medical grievances, not necessarily the 30-day, because I think for a medical grievance, 30 days is actually an extremely long time to be able to address issues. So I'm hoping that at some future point, and again, through the chair, that there may be an opportunity to dive a little more deeply into what you're responding to, how you're able to respond to it, and then what should our medical grievance response timeline be? Because it does feel like that should be much shorter to me than 30 days.
Thank you, Supervisor Chavez, for the question. We are working on an analysis of recategorizing those grievances into categories that make sense and align to the requirements of both Title 15 and the consent decree. So they will be varying timelines depending on the situation. For instance, medication follow-up, or that folks weren't seen within a specific time frame. So we are looking at that, and it's just going to take us a little time. We were a little bit behind on our follow-up on all our grievances, but that is something that we are looking at, and we're happy to report back on our status on where that is.
Yeah, and
we may need a different system. I just want to put a plug in there. The system itself doesn't always work, or it doesn't lend itself to the analysis on the medical side, but we will be working with our custody partners to figure this out.
So that would be great. And again, through the chair, I would just leave that to you and your staff to tell us when an appropriate time to come back is. And I will just add one other thing as it relates to medical. I do think that both the timing is important, the type of response is really critical as well. We have gotten feedback at the reentry center, reentry committee about folks not being diagnosed properly and not getting the follow-up they need. And so one other issue as it relates to grievances that come to you is I'm interested in understanding how, when our employees are observing somebody who's in custody that needs additional help, whether that's a sheriff or a custody officer or somebody else, whether or not, if they're putting in a recommendation for that person to be seen, how fast we're seeing that person based on a staff person's recommendation that they need additional services. So if you could think about how to quantify that, that's really important. And Sheriff, I would just say that I know we have to make sure that everybody feels comfortable in custody, in those environments, those work environments. But I want to make sure that your team understands that the observations they're making are in fact being responded to, and I'm not sure how that's working right now. And some of the feedback I've gotten about people maybe being misdiagnosed and not having quick follow-up have actually come from family members and then people who are in the jails who are providing different kinds of services, volunteer, who work for us. And so I don't know the right way to resolve that, but I think it is a really, really important issue, because some of the extreme behaviors where people have been injured seem to have a pattern of us not responding quickly enough to somebody sending up a red flag. And we should be encouraging people to send up red flags, which is the only way I don't know a better way to do that, but I did want to put that on the radar of the chair. Thank you. Thank you.
Thank you. Did you have other questions?
I'm good. Thank you.
Thanks. Sheriff Johnson, I'm interested in your thoughts on the Moss Group's characterization of the grievance unit as more focused on data analysis of complaints rather than being directly involved in grievance resolutions and internal improvements, as is, I believe, standard with other correctional grievance units. And then bigger picture overall, what are the planned next steps to address the recommendations of the Moss Group? What's your timing on that?
Yeah, great question. The as I'm still learning the different processes and protocols within the organization, one of the things about the grievance unit that I have to give them a compliment on is building up that system based on the consent decrees, and really getting a system in place where we can identify where the complaints are coming from, the responses to those, how quickly they're being addressed. I think when it comes to the Moss Group's evaluation, we're always willing to hear and listen and evaluate whether we can adjust those. But I think, as the lieutenant mentioned, a lot of times when a complaint comes in, a grievance comes in, their job is to enter it, submit it, identify where it would best be addressed, and ship it out, and then obviously get the return on that and go for it. So they're not always personally engaged in all of it. I think there may be room for improvement moving forward, and I think that's something we'll continually look at in doing so as we address the different issues.
Thank you. I would be interested in having a report come back to this committee on your planned implementation of or disagreement with the recommendations. Is there a time frame in which you're already thinking about doing that?
Yeah, I would probably defer to the lieutenant and Laura as far as timeliness of that, because they're most engaged with the Moss Group right now.
Great.
So we're actively collaborating with the Moss Group, and we've taken a lot of the recommendations into review, and we can report back in June.
June? That would be fantastic. Thank you so much. I appreciate it. We have a motion?
I'll
Did we have a
move
motion?
that we
Okay.
receive the report with the report back in June regarding the Moss Group. A report back also in June just on what should our goals be by subject matter in terms of resolution, and to ask that Dr. Luna have an opportunity to work with the chair's office on an appropriate timeline to report back on an overall custody health strategy relative to grievances.
I will second that. There was no public comment on this item. Let's vote, please.
Vice Chairperson Chavez.
Yes.
And Chairperson Ellenberg.
Yes.
Motion carries.
Thank you very much. Thank you all for the report today. Item 7 is a semi-annual countywide criminal gang activity report, I believe being presented by the District Attorney's Office.
Good morning. So we have presented this report a number of times previously. Brian Slater, who is the supervisor of the gang unit, is also here. Perhaps I'm just going to make some highlights and then see if anybody has any questions.
Perfect.
But due to changes in the law over the last 5 years or so, also not just legislation, but also case laws, and also just really trying to listen to the courts, we have really drastically changed our policy on charging the gang enhancement. Not necessarily policy, but maybe our procedures. In addition to that, Mr. Slater tends to have a much more conservative view on charging the gang enhancement, and therefore the number of times we charge the gang enhancement has gone down considerably in the last several years. We tend to now only charge the gang enhancement on cases that are really, really violent or serious. So we tend to see the cases in our unit now are predominantly murder, attempted murder, and extremely serious assaults involving guns or knives that happen either in custody or out of custody. Obviously, gang crime in our county continues to disproportionately affect communities of color, both in those individuals who are influenced to get involved in gang activity, but also those that are victimized by gang activity, either themselves or their family members. We wanted to look at this last time, the one thing that we looked at differently, because we have received questions at every time that we've presented, is what does our filing look like? And we did only look at the last year of filing cases and whether or not we are disproportionately filing against people of color. Now, obviously this statistic is very flawed because a majority of the cases that are brought to us by law enforcement are involving people of color. But when we looked at the last year, we did not see that we are disproportionately not filing on white individuals who are gang members in our county. That is one statistic that we gave you. It is only involving this last year. But based on that, I'll submit the report and see if anybody has any specific questions that perhaps Supervisor Slater can answer best.
Thank you very no pressure. Thank you. Do we have public speakers on this item, Colin?
We have one request to speak virtually.
All right, let's hear our speaker, please.
Next speaker is resident. You'll have 2 minutes to speak. The timer will start when you begin speaking.
Yes, there's one thing that you guys didn't include in this report. I mean, you guys just really focus on Latin gangs and things like that, but Valerie Houghton has a gang of her own. And when I complained about what was happening to my kids, which was quite serious, she had me hacked, stalked, and assaulted. And I mean, I've been poisoned so many times that my testicles have atrophied. I've lost sensation across my entire body. All my organs have been damaged. It's just, these kinds of things need to be addressed. Just because Valerie Houghton is an attorney, it doesn't give her the right to be doing these things to me. And by you guys not addressing it, I mean, that's basically what you guys are doing. And I mean, like, even the shape of my face has changed from all the poison. And I mean, I posted it online. If you just Google Valerie Houghton poison, you'll see the great bodily harm that she's done to me. You'll see pictures of it. You'll see the social media posts that she's posting publicly, threatening me, that she's directed me to view. I mean, it's just, she's just a really dangerous person. And I can't believe that everybody's looking the other way as she's doing all these crazy things to kids and to families. And it's just not just me. I mean, go to freeariana.org. I mean, this other dad, he got poisoned too. And Valerie Houghton isn't denying that she did it. I asked her and she won't deny it. And his kid is also being sexually abused. So I really hope that you guys can include this into your report. And again, if you guys could help my kids, just pick up a phone, lift a finger. Thank you very much.
That concludes our request to speak.
Thank you very much. Supervisor Chavez, do you have questions?
I do. I have a few questions. One is, as you look at this report, how are you looking at an increase or decrease in gang activity year over year? And part of the reason I'm asking the question is that as part of the mayor's, I forgot what the new name of the mayor's gang task force is, but they are looking at quarterly issues relative to young people. But I've never seen a report that looks at adults, and I'm presuming that these numbers are adults or youth being charged as adults because of the seriousness of the crime.
Yes, the report would include only adults or juveniles who were transferred to adult court, but I would say that is a fairly unusual circumstance now. We're not having very many juveniles that are transferred to adult court. When we looked at this, we did not compare last year, for instance, 2022 to 2023. We can do that, however. My impression is the numbers have been relatively steady as far as how frequently or how many people we are charging with gang crimes since the gang law has been reformed a couple of years ago. But we can certainly run those numbers and get them for you.
You know, one reason I think that's important is that following trends year over year, both relative to murder, the level of violent crime, and the even the types of gangs that we're seeing, I think would actually be really important for the committee to understand, in part because I think gang activity is changing quite a lot. And for many of us who've lived in this community for generations now, long time, there's a lot of investments that have been made, for example, in youth and in trying to remove young people from gang life. It would be important to understand whether or not we're having some success, and one of the indices of that would be how many adults we're seeing that are still involved in that lifestyle and committing those types of crimes. And I also I've been curious about whether or not the changes in law, how that impacts who we're seeing in custody versus who we're not seeing now. And I know it's a very complex, so let me just say this. I recognize this is very complex, and also in the district that I represent the downtown east side and southeast side of San Jose. So the violent crime rate still, even though our numbers are dropping, it's very clear to me that we're seeing some emerging trends relative to gangs. And one thing I've been also mindful of is the number of people that may not die from gang violence, but they end up in the hospitals, in part because VMC and other hospitals do a really good job of saving people's lives. So I would just like, when you do these annual reports, for you just to be able to give us a flavor of how the work that we're doing, especially at this adult level, is reflected in our overall numbers, because it would help me understand a lot more about what we're doing at a juvenile level that is or isn't having an impact on young adults.
Supervisor Chavez, I think that's an incredibly insightful thing. I think what you haven't asked us to do previously, we only have an adult gang unit. However, a lot of our significant juvenile crime, and when we're talking about the youth that are detained, involves gang crime. And so perhaps next time we merge both of those units and do a report together so that it reflects both our juvenile population and our adult population. As you know, most of our violent street gang crime is committed by younger adults and our juveniles. And it has been disheartening to continue to see really, really young gang members, 13, 14, 15, committing really, really violent crime. So I think perhaps what we haven't done before is haven't really pulled the numbers from juvenile before when we've presented this report.
So, Nick, Chief.
I would also take a look at not just juvenile and adult, but I would also break the adult into age 18 to 25 so that we really get a clear picture of that
Yeah, that
transition
would be
age youth that
helpful.
move from juvenile into the adult system relative to that age group, because significant number fall within that age group.
You know what? That's a really excellent point. And President Ellenberg, the reason I'm asking the question is that as part of the action the board took to take a look at blue zones, it also allowed us to have a joint meeting between our neighborhood, our Children's Family Seniors Committee and the Neighborhood Services Committee for the city of San Jose. And so what we're taking a deep look at is their master plan for youth. And so what I'm hoping is that as we look at metrics for the future, if we're looking at really these deeper investments in prevention, that we're actually going to be able to track via the census tracts and the zip codes, the folks that we're seeing at these younger ages on intervention and prevention, and determine whether or not because really we should be looking at this over 5, 10 a year span. And I feel like that disconnect between youth and adults hasn't allowed us to be really rigorous in terms of determining whether or not we are doing what we need to do to really cull that group down as much as possible that end up in these committing crimes as adults. So that would be really helpful. And I'd love the idea of the District Attorney's Office and probation working together on that. Thank you.
I agree and support that very much. Is this work that is happening or that you would want to move to CFSC, given both your leadership here and the focus?
No, I
on-
actually think it's appropriate for here, but
Okay.
the youth master plan, the youth services master plan, the city's adopting it with a ton of county input, and we're doing a joint meeting to review it. And then it'll go to the City of San Jose's board. And then what I'm hoping happens is that we can actually have it reviewed in both this committee and potentially, I'm not sure, Susan, we should think a little bit about that. But given the amount of investments we're making in our partnership specifically with the City of San Jose, and I hope an expanded partnership with the City of Gilroy, this really should be on our list to determine expenditures, like what the spend looks like at a local level. And this is actually tied to our Blue Zones work as well. So this is a perfect time to actually have a conversation about the metrics and the indices. And we should make sure that both of your departments I know you've already been involved in the Youth Master Plan, but both departments, Dr. Luna, I think we're tasking you with being our leader on Blue Zones, but I think maybe having that conversation with our team would be helpful. Thank you. I'd make a motion for that if you want to. Do you have questions too?
No, I'm just thinking it through because we also have our own Office of Children and Families policy, strategic planning process.
Yeah, actually, I left
working.
that out. I always want to call Sarah a doctor. I just add that. But so Sarah has been playing a leadership role on converging the two plans. And so what we did when we met with the City of San Jose is I asked her to present her plan. The city presented highlights on their plan so we can integrate them together. So we're looking at littles to olders, because we're really looking at littles. Yeah. I mean, preschools and stuff. So,
Okay, good.
yeah.
I just wanted to make
Yeah.
sure that that's.
And what I'm
that's
hoping
all
comes back
connected.
is a shared vision. That's why we're doing the meetings together. And that's partly why we were using Blue Zones to connect it all together. Yeah. Great.
All right, thank you.
That'll be my motion.
All right, happy to second that.
Vice Chairperson Chavez
Yes.
and Chairperson Ellenberg.
Yes.
Motion carries.
Thank you very much. Item 8 is announcements. I want to just start by making a clarification on comments that I made during my presentation of the PSJC 2024 work plan. The agendized new jail discussions would actually be more appropriately described as reports to this committee on the facility needs assessment and the jail population analysis that are currently underway. I know for members of the public, the last public item regarding a new jail occurred really when the board voted to pause moving forward with J.E. Dunn, who was a previously considered contractor on the jail design, and the board determined at that time that the entire issue of a new jail be considered anew given the changes in the jail population and needs. So and Greta, I'm looking to you to correct if I make any misstatements here. After the current assessments are complete, we'll have an updated perspective on what kind of building facilities and how many the county may need to construct to meet the needs of individuals who are required to be held in custody, which could be a range of types of facilities, including treatment-focused ones. And at that time, before further action is taken, county administration will undertake a new public engagement process regarding design of the facilities.
That's right, and I maybe I'll just add another brief comment, which is, as we've been thinking through, and frankly also just been experiencing some really significant challenges at a whole array of our custody facilities related to just their age, the population that's utilizing them, the fact that they're really not the facilities in any way, shape, or form that any of us would build today for the populations we're serving, and the challenges we're facing in even being able to provide, for example, the level and type of medical care with the level of staffing from the Sheriff's Custody Bureau that we have. We do feel like these comprehensive assessments are going to really lay the framework for what are the array of investments needed to actually provide the level of constitutional and appropriate and rehabilitative care that we want to provide in the jails, soup to nuts, and then to be able to lay out a more thoughtful plan on the way we could invest in trying to achieve that future state and in what order. But because what maybe the outcome of that more holistic assessment could vary significantly, and therefore what type of outreach would be appropriate based on the types of projects that might be included, we do want to complete those assessments to just have a baseline understanding that we would then use as the core of what we'd be engaging the appropriate community stakeholders about, including our staff who work in those facilities as critical stakeholders, in addition to the community members, folks who have a deep connection to our inmates, the whole array of stakeholders whose voices we think would be really critical, but with that much greater information.
Thank you very much. So a much broader engagement than limited to design. So thank you. Thank you for clarifying that. I'll also share briefly that I'm offering on behalf of the board a State of the County address on January 25th, I think at 5 o'clock, probably. Hopefully you've all seen information about that, and the theme relevant to this committee is building safe communities. So I do hope that you will all join me, and just please check the correct starting time on Thursday, January 25th. Our next meeting is a joint meeting that was requested by the City of San Jose and will be hosted at City Hall Council Chambers at 200 East Santa Clara Street. So please note the change of venue for our next meeting. That meeting's goal is to seek to improve coordination of city and county strategies for serving people who come into frequent contact with the justice system, and it will include presentations from city and county departments on existing and emerging strategies. What date? February 15th at 10 a.m. And thank you to my team for confirming the State of the County is at 5 o'clock on January 25th, right here in Chambers.
That's awesome.
Are there other announcements from any other folks up on the dais? Supervisor Chavez.
Thanks. I just have one quick announcement, and that is with the governor's budget, there's a lot of really important grants that we were going to be competing for and wanting, and some that we even competed for and maybe won that are going to be slowed down. And one thing that I'm going to ask my staff to do is send out the analysis that was done by the BSCC, because it shows the grants that will and won't be available. And I know all of us apply for those, so I'll ask Jack to get that out to everyone. I did think that maybe at one of our next meetings, there could be a lot of value in having a deeper dive into what will and won't be available in this realm, just so we can do some proper planning over the next couple of years.
Good. Thank you very much, Greta. Okay. Looking for any other lights? Yes,
I have a light on.
Please.
I'll be brief, but my data is very rough. I just wanted to report out on the backlog in the court, because I will be missing some meetings in February. Greta had asked at the stress test meeting for the court to report out on improvements in the backlog made in 2023. So let me start by thanking the sheriff, because with the sheriff's prioritization of the court, you all recall we discussed in here, we opened 3 additional felony trial departments in April and May. We also converted 2 civil trial departments into misdemeanor trial departments. So for much of last year, we ran 5 additional criminal courtrooms only because the sheriffs gave us the deputies to do so, and the people sitting on this dais staffed their offices in a way to make that happen. So please forgive my gross sort of generalities, but here's the bottom line. The number of time not waived cases we had last year between the first quarter of the year varied between 680 and 840, and we routinely had a number of time waived cases also sitting in the jail. That number also varied around 300. As I sit here today, our time waived and time not waived combined is 100 cases less than just our time not waived cases last year. And that is solely based on the increased staffing that we were afforded.
Can you say what that number, even the approximate, 100 less than the total?
You know, I knew that someone would want me to dive a little deep. Our numbers are very, very rough, and we tried to pull them so that Aaron Harris could use that data directly to report out on the consent decree. All I can say, we're significantly lower, and now we're combining them so that we're not just looking at time not waived cases or time waived cases. We're looking at that as our entire backlog, and it's significantly lower. It has come at a cost. Our civil division now has 650 backlogged civil trials between January and July of this year. So they, you know, we have simply shifted the problem someplace else, but we have significantly reduced the number of backlogged both felony and misdemeanor cases, both time waived and time not waived. And I will have more specific data, but I'm afraid I won't be here when we next meet, so I'll have Judge Emity bring the actual numbers. Thank you.
Thank you so much, and that really is exciting and impressive work. So thank you to all of the departments that make that possible. Any other final announcements? If not, we are adjourned, and we'll see you at City Hall on February 15th at 10 a.m.
Thank you. I love that you use that gavel.
It's satisfying.
That's how it is. It makes you feel like you checked a list.
Right.